I'm Marcia Holland. I will be the chief judge for this presentation. I'm in Missoula, Montana, although my legal career was as a career public defender in Alaska. But when I moved to Montana, I now teach at the law school here in Missoula.
I'm Ben Glickman. I'm a supervising deputy attorney general with the state of California. Far more importantly, I'm an alumnus of this program and was lucky enough to be on a national championship team way back in 1995. So just a little bit before your lives and before Zoom.
My name is Candida Steel, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, but I've also been with this program about 20 years, and it's the highlight of my year, that's for sure. I hope you really enjoy this.
And if you could introduce yourselves and also your teacher or any mentor that's participating virtually.
Hi, my name is Katherine Tong. Outside of We the People, I was MVP of my tennis team, and I started my community-wide anti-drug campaign.
Hello, I'm Chloe Menzies. Outside of We the People, I started my school's recycling initiative, I played a trumpet, and I will be attending Wake Forest University to study sociology and public policy.
Good afternoon, my name is Olivia Schneider. Outside of We the People, I'm senior class president and president of Build On, and next fall I will be studying marine science at the University of Miami. And we're here today with our teacher, Mr. Milton Himes.
Thank you. Thank you. And so it's no surprise that this is Unit 3, Question 3. I will read it in its entirety, and then you may begin your presentation, and the time will begin. In 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between these two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? And you may begin.
American suffragist Carrie Chapman Catt stated, "We women demand an equal voice. We shall accept nothing less." The 19th Amendment granted women the same voting rights as men, but it only started the long struggle for equality.
The 19th Amendment states, "The right to vote shall not be denied or abridged by the United States on account of sex." However, this language failed to enfranchise many groups of women. Additional legislation, such as the Snyder Act, Magnuson Act, McCarran-Walter Act, and Voting Rights Act, had to be passed to enfranchise most minority women.
Other legislation built on this equality inspired by the 19th Amendment, the Equal Pay Act, Title IX, Pregnancy Discrimination Act, and Violence Against Women Act have mostly used the Commerce Clause to improve equality in the United States. Yet, other countries have surpassed America as a leader in women's rights.
For example, the United States, along with 8 other countries such as Iran and Sudan, have failed to ratify an international treaty guaranteeing gender equality, called the Convention on the Elimination of All Forms of Discrimination Against Women.
Another indicator suggesting that our country has fallen behind on gender issues comes from the UN's Gender Inequality Index. Currently, the United States ranks 13th based on 3 factors: reproductive health, empowerment, and economic status. Other countries, like Germany, rank higher because their constitutions explicitly ensure equality for women.
Alice Paul, an American suffragist, states, "We shall not be safe until the principle of equal rights is written into the framework of our government." The major differences between the ERA and the 19th Amendment are that the ERA has not been ratified and is far more expansive.
The ERA was passed in Congress with a 7-year time limit. It was then ratified by 35 states, but ultimately fell short of ratification. Currently, efforts to revive the ERA are being questioned due to the possibility of ratification through litigation after Nevada, Illinois, and Virginia recently ratified it.
While both the 19th Amendment and ERA ensure equality, the ERA would enhance women's rights. Former President Lyndon B. Johnson stated, We have talked long enough in our country about equal rights. It is now time to write it in the books of law. This amendment would establish equality in areas such as pay, reproductive rights, and gender-based violence.
Currently, 38 states have ratified ERAs. State ERAs are advantageous to citizens because they can provide better protections. The Colorado, Hawaii, and Delaware Constitutions state, equality of rights under the law shall not be denied or abridged by the state or any of its political subdivisions because of sex. According to The Hill, these states rank among the top 10 best states to be a woman in.
However, a major disadvantage of state-by-state ratifications is that courts can interpret ERAs with less impact than they might under a national amendment.
A national ERA would make sex a suspect class, like race and religion, changing the level of scrutiny applied to sex-based discrimination, which is currently decided using the intermediate scrutiny standard established in Craig v. Boren. Furthermore, it would overturn the case United States v. Morrison that held part of the Violence Against Women Act of 1994 as unconstitutional.
Women have made significant advances in equality, but without the words placed in the Constitution, it will only ever be assumed. As Supreme Court Justice Ruth Bader Ginsburg states, every constitution written since the end of World War II includes a provision that men and women are of equal stature, but ours does not. Thank you.
Thank you. And now put your notes away, although it's the honor system, so we're assuming that has happened. So Ben, do you want to ask the first question?
Sure.
As a follow-up?
So I guess I'm a little confused. Why do we need the ERA when we've already got the Equal Protection Clause of the 14th Amendment? Why can't just a robust reading of the 14th Amendment be enough here?
The Equal Protection Clause has failed us as women because using the scrutiny standards, sex-based laws are evaluated under intermediate scrutiny. However, if it was raised to a strict scrutiny standard, then restrictions that states are allowed to make on abortions established in Planned Parenthood v. Casey would not be constitutional. And furthermore, we can see in other cases regarding abortion, such as Bellotti v. Baird, that when states tried to make laws prohibiting minors from receiving abortions, that they couldn't. However, these laws wouldn't have even put in place had these been evaluated under a strict scrutiny standard.
Additionally, state action limits the Equal Protection Clause of the 14th Amendment. So where there's no state action, women need other legislation to challenge discrimination, such as the Violence Against Women Act.
We continuously see the 14th Amendment's Equal Protection Clause failing, specifically with women and needing the 19th Amendment. If the 14th Amendment's Equal Protection Clause truly held equality, then Minor v. Happersett would have been decided the other way and women would have been granted the right to vote earlier.
Judge Steele, did you have a question? You're on mute, by the way.
Trying very hard not to have everybody here who's walking around in my house. Virginia became the 38th state to pass the ERA. Do you think that the amendment should be ratified? I mean, the ratification should be archived to the amendment adopted, basically?
I do believe this amendment should be ratified. It states in Section 3 that this amendment will be placed in the Constitution 2 years after its ratification. And additionally, the most recent amendment, the 27th Amendment, was first proposed by Madison more than 203 years ago. So therefore, I don't think the time limit argument is valid for the ERA.
I would agree with Olivia. We can see in Coleman v. Miller that the courts decided that states cannot rescind their ratification of amendments, and it has been argued whether or not they have the ability to do this. Since this has not been claimed as a power that the states have, since there have been 38 ratifications of this amendment, it should pass.
Building off of Chloe's point, nowhere in Article 5 does it state that states have the power to rescind their ratification. Additionally, we can see with the passing of the 14th Amendment, New Jersey and Ohio tried to rescind their ratifications, and it still passed. Additionally, with the 15th Amendment, New York tried to as well, and with the 19th Amendment, Tennessee tried to.
So I want to follow up with a slightly different question. back in the 70s, when the ERA was getting much more traction, there was actually a group of women primarily who were opposed to it. And the current wording of that proposed Equal Rights Amendment was the cause of some concern. Can you identify the arguments for and against the language that was used, especially in Section 1 and Section 2? And if you're looking at those concerns in the light of, we're now in 2020, are those concerns now still legitimate?
One argument that Phyllis Schlafly used in her opposition against the ERA was that it would grant gays right to marry. However, we can see in the recent decision of Obergefell v. Hodges that this is a constitutional right that they were granted, and the ERA, therefore, that argument would have no place today.
Additional arguments against the ERA in the 70s was that it would eliminate single-sex bathrooms and that all public bathrooms would be same-sex. This is another argument that we see arising in today's world about same-sex bathrooms, but we can see that the ERA is up to the court's interpretation of it, and unless the court swings that way, the bathrooms in public will resume as normal.
Additional worries that were introduced, came up when it was first introduced, was that women would be included in the draft. However, this power is decided by Congress, so that would not have been a worry of the amendment if there was a fuller understanding of what the amendment would achieve.
And additionally, in Rosker v. Goldberg, they decided that a male-only draft was constitutional, so it would not be a worry today anyways.
Ben, did you have a question? You're on mute, Ben.
Sorry, you touched on this just a bit ago, but are there any circumstances in where it's appropriate for government to distinguish based on sex or gender, where it's okay to do so? What might those circumstances be?
Yes, there are certain circumstances where it is okay. The court decided in Con v. Shevin that something that exempted widows from property tax was constitutional because the purpose was to close the economic gap between men and women.
Judge Steele, did you have a question? I think we're going to bump up against the time limit. Okay, she's on mute too. So Elisa, can we give these guys an extra minute because of the muting and unmuting problem?
I'm sorry. Does Joe Biden's promise to choose a woman as his vice presidential running mate violate the spirit of the ERA or support the consistent with the spirit of the ERA?
It is definitely consistent with the spirit of the ERA. We have never had a woman president or a woman vice president, so now would definitely be the time to enact this. However, I don't think that we can talk about Joe Biden without bringing up the fact that he has been accused of sexual assault along with President Trump, and this is just embarrassing for women everywhere to have to choose between these two candidates.
Additionally, this promise of having a female running mate brings into question who he would pick. If he were to pick Kamala Harris, she is the first candidate who has proposed some type of solution to the rape back hit log by proposing a $1 billion solution to eliminate this in our police systems.
Thanks. Well, thank you very much. And you get to sit back and take a breath, and there'd be a huge round of applause. It's a tiny round of applause today. And there's even virtual applause going on as well. And so I'll go ahead and start with feedback, and then Ben, and then Candida. So it was impressive to hear the amount of detail that you researched to determine all the acts that it took to make the 19th Amendment actually be viable. You know, one after another, you listed them. And I think that's a very powerful way to present information that the 19th Amendment wasn't the panacea that everyone hoped it would be. So very impressive in terms of that level of research and presentation as well, just in terms of making that point driven home. The idea, the concepts you raised in answering my question about what was going on at the time were all the things I was thinking about too. I have to ask, and you don't have to answer, but I've been binge watching Mrs. America to get ready for this competition once I saw the question. And it is really interesting to see what the pros and cons were back in the 70s, especially the draft issue. And you brought up a really good point. That's a congressional decision. And that's a level of looking into a potential question that I hadn't even anticipated. That was really good. And so overall, just great job, really good job.
Yeah, I would agree. I thought you did a very nice job on the prepared remarks, talking about how our country has fallen behind on some of these issues, and citing, actual source material for that statement is impressive. I thought your discussion of the state versus national amendment was very good. In particular, I like the notion that a huge benefit of a national amendment would be that it would force the court's hand in changing the level of scrutiny, which obviously would have significant consequences. So I thought that was great. On the Q&A, I was very impressed. Again, you parried all of our questions. You had good supporting evidence. It was clear that you understood the supporting evidence you were citing. In particular, on my first question, it makes me think my question was too easy about why do we need it in light of the 14th Amendment, because you guys just crushed it. You just went down the line and just hit everything I was looking for. I just wrote A+ in that box on my score sheet. So you did a really nice job on that question, and likewise on the remainder. So very nicely done.
Great, I agree. I think it was absolutely wonderful presentation. Thank you. I agree with my colleagues. The only thing I'd throw in, and I really appreciated your discussion of Article 5, and gay's right to marry was really interesting thought. Thank you. I think you did a really lovely job. So one of you, I think, mentioned that you were interested in politics or government policy in some fashion. Well, I hope all of you will be, I know you will all be much better citizens than 99% of your cohort. But I think you also, I hope, might have been bitten enough by this experience that you might want to go on and do something to do with this experience in your life. I have a cousin who did this program in 2000 and has just gotten a PhD from Oxford, so in political science. So this is a really good way to launch yourselves into a career if this interests you. In any event, I'm really happy to think of all of you continuing to represent the rest of us somehow as citizens, or in some other fashion as representatives or senators or lawyers or judges. You all certainly have done better than anybody in my constitutional law class. And so I will rest easy in my old age when I'm sitting in my rocking chair in my own home, maybe right now, not a nursing home. But anyway, I hope you'll have a wonderful time, and you've really shown that you understand this, and you must be interested by it to have done as much as you have. Thank you. It's been a pleasure listening to all of you.
Thank you.